Let's go back now to Brunswick, Georgia. We have with us Travis McMichael's attorney, Bob Rubin, and Franklin Hogue, who is Gregory McMichael's attorney. Gentlemen, thank you both so much for joining us. I'm Ashley Willcott. I know I've not met you before. Certainly appreciate your time. Let me ask you this. If I could start with you, please, Bob. How do you view today's motion hearings in terms of whether or not it is a win for the defense?
Well, thank you for having us on. Unlike baseball, football, basketball, I don't think you count this in terms of win-loss. This is a long process. I think Judge Walmsley did a very good job kind of organizing us and dealing with the various issues that were raised. The state raised a lot of issues in their motions in limine. Most were denied or deferred, which I think was good. We had a couple pretrial motions in limine. I don't know offhand which one was granted or denied, but I think we fared well on those as well. And so overall, I'm very pleased with the way the day went. I think we're allowed to argue our case. I think the judge will let us argue our case. He wants us to be professional and prepared, as he put it, and we have every intention of living up to that.
And if I could, Franklin, ask you the same question. Any other comments you could share with us about today's pretrial hearing?
Well, no, I agree completely with Bob. I mean, you try these cases an inch at a time. A lot of motions work is incremental, and we're just crawling through them. We win some, we lose some. That's totally expected. But echoing what Bob just said, I think we have a very careful judge who's creating an atmosphere for a fair trial. And what more could a defendant want? We just want a fair shot.
Right. And I will tell you, I certainly agree. Just watching him, he's very efficient. I appreciate that he makes rulings, or he says we're going to defer that until a later point in time. If I could ask you specifically about a motion to tender a video by the state, and the state basically said, I wanted defense to have notice of how we're going to try to get this in under the rules of evidence, give the court notice, and by filing these motions that then everyone has notice of what we intend to do to be more transparent, my words, not hers, at trial. Do you feel, Bob, like this is true, that this is a state and the prosecution is filing things to give you an idea of transparency in terms of how they're going to proceed?
So the purpose of the motion is to deal with any objections in advance so that they're not stuck in the middle of an opening statement with an objection that they can't deal with at that time, or that throws them off in their opening statement. It makes a lot of sense to try to deal with as many evidentiary issues in advance as possible for both sides. It's certainly no surprise that the state wants to introduce the video, the one that the public has seen time and again, into the case. But I'll tell you, we intend to introduce that video as well, and to show the jury the various aspects of that video that we think fully support Travis McMichael and Greg McMichael's defenses.
And Franklin, how would you characterize, or how do you feel about today's addressing of the guns and gunshots and some things that happened previously that the state had wanted to get into evidence?
You're talking about the one buckshot pellet that went into a neighbor's, through a window and into an air duct, I take it. I don't know which lawyer argued it. I can't remember that now, but the argument was that it's irrelevant. That was overruled. I think it's coming in now, based on what I recall. I don't see it as a big deal. A single buckshot from a shotgun fired 3 times ends up in a neighbor's air duct in his house. I can't imagine why that's important to the state to introduce, but they get to tell the jury about it.
So, Franklin, let me also ask you this. I have to tell you, watching today, I have so much respect for the professionalism that you all have shown, that all of the attorneys in the courtroom have shown. Of course, as attorneys, we prepare for trial. There are going to be emotional times, but for the most part, there is a level of respect and professionalism that I think should be demanded in a courtroom, but certainly I have observed. Having said that, how is your client doing? We know, Franklin, that you represent Gregory. How is he doing at this stage in this proceeding?
Well, having been in courtrooms himself over the years many, many times as a DA's investigator and a law enforcement officer, sorry about the train there, he gets it. He understands that his lawyers have to act professionally, and that's what we'll do. In fact, we do that whether our clients expect it of us or not. And all of the lawyers in this case are pros. We've been doing this a long time. We understand each other's role. He's doing well. He gets that. He wants us to litigate hard. He sees that we're doing that, and he's pleased with that. He sees that we're not leaving any stone unturned in this case.
And I can't decide if it would be easier or harder to have been involved with law enforcement and then in a situation like this, because you do have a different knowledge and idea of the system and how it works and what happens. Bob, same question for you. How is Travis doing at this point in these proceedings?
I'll tell you that it's a struggle. He's been locked up for over a year. Bond was denied. Even though I didn't feel like he posed a risk, the judge felt a risk to flee. The judge felt otherwise. So he's been having to sit in seclusion, essentially, for a year, waiting for this trial to begin and for his story of innocence to be told. And so that's hard. He's lost 40, 50 pounds in that time period. And so it's a struggle, I think, to get through the day, keeping the right mindset and staying optimistic. And all that being said, I think he is in the right frame of mind. And I think he is optimistic that we're going to fully put forth his story of innocence.
And let me back up a step, because I'm sure that you all hear this as defense attorneys, and I know viewers talk about it a lot. When you have a case like this that has so much attention, and there is a video that many people, most people have watched, was it a hard decision? And Bob, let me just start with you again, if I could, please, sir, to represent one of these three, there are three defendants, but father, son, to represent one of these defendants in a case like this?
Absolutely not. It's not hard at all. 35 years ago, I signed up for this because I truly believe in every defendant's right to counsel. And without that right, the system does not work. I have represented all sorts of people, and I'll tell you the truth, I like Travis McMichael. I think he's a good person, and I think that information needs to be told to the jury, and I think his story needs to be told to the jury. I have no problem whatsoever representing him.
And Franklin, same question in terms of making a decision in representing Gregory in this case. Was that, tell a little bit for viewers to understand your decision to do that?
Well, in 30 years of defending people accused of crimes, I've never turned down one single case just because of the crime charged. Like Bob said, you sign up to be a criminal defense lawyer, you should be willing to assume the representation of any person at any time charged with any crime, no matter how unpopular it is. In fact, the more unpopular, the more they need lawyers like us who do what we do. We're the only lawyers mentioned in the U.S. Constitution, and I take that seriously. I take my role seriously, and I'm honored to represent Greg McMichael.
And many of the motions that were heard today have been filed by all of you as defense attorneys for all three of these defendants to seek every step necessary to obviously seat an impartial jury. Glenn County, Georgia is not a huge metropolitan city. How difficult do you think it's going to be, Franklin, to have an impartial jury that isn't predisposed based on something they've seen or heard or have already made a decision or have any type of bias?
It's going to be difficult, but it's not going to be impossible. It's going to take a lot of painstaking, long days questioning prospective jurors, and I expect we're going to go through hundreds of people before we get 12 jurors seated. But I also believe that when we get those 12, they will be the fairest and most impartial of all of the jurors that we interview. So it'll be difficult, but it won't be impossible.
And listen, I say publicly all the time, I believe in our jury system. And so the benefit to having defense attorneys and prosecutors in a case like this filing all these motions is to make certain that the law is followed, that our Constitution is respected and followed, and that you have an impartial jury. Bob, let me ask you the same question. How hard do you think it's going to be to accomplish that in a smaller community?
I think it's going to be difficult. Obviously, the nation has been inundated with information, and this community especially has been inundated with information, stories in the print and broadcast media. My biggest concern, and I hope we can address that fully once jury selection starts, is that the jurors feel safe, that they feel like they can be honest with.
All right, it seems like we've lost our audio, and we're going to take a really quick break, but we'll be right back here on Court TV, your front row seat to justice.
I'm not know that we're fighting. The motion asks the court to make a ruling today on a piece of evidence, and the court's never heard the first witness. If the state lays a foundation under 923, great. Well, I anticipate they can lay that foundation. But it just seems premature to ask the court to rule on the admissibility of evidence before the court's heard the witnesses lay the foundation.
And I guess what the state was doing was, did you want to hear the witnesses before we get to trial? Or?
I have no interest in trying this case until we try this case.
Okay.
All right, that was Bob Rubin, the attorney for Travis McMichael, that was just arguing earlier today on a pretrial motion. Also with us from Glenn County, Georgia, we also have Franklin Hogue, who is Gregory McMichael's attorney. Sorry, we lost you there for a minute, gentlemen. Let me ask you, Bob, you were commenting on the impartial jury aspect of this trial. Was there anything else you wanted to add to your thoughts about that first?
I don't know where we got cut off. I just want to say that our big concern is for the jury to feel like they're in a safe environment during jury selection so that they can honestly and candidly discuss with us the various sensitive issues that are inherent in the case. And if we can get that, then we'll get a jury in this case in this county.
Do you expect that they're going to be sequestered for the duration of the actual trial?
I don't.
No, I don't
no
think
one's
so.
asking for it. I don't expect the jury to be sequestered. I believe they'll be able to go home every night.
All right. So let's talk a little bit about some of the evidence. And one of the things that you mentioned, Bob, the video, and I neglected to ask and meant to, is there any part of the video that we haven't seen? Is there more to that video that you expect you're going to try to get into evidence during the trial?
You know, I believe it's like 36 seconds of a video that has hit the airwaves. There's certainly more to the story than that 36 seconds. That's a very small part of the story of this case. And we expect to, in great detail, get into the history that led up to those 36 seconds and the events of February 23rd.
And Franklin, what we heard earlier today, and I just wasn't familiar with it, was there may be evidence that the victim, Arbery, in this case, touched Roddy Byron's car. And by touched, I mean there was a print of maybe a hand. A, is that accurate? And B, is that another piece that you hope to present as part of the story on behalf of your client?
Well, I think that piece of evidence will come in. What it means is highly in dispute. I think Roddy Bryan's lawyer will be the one dealing with that issue primarily. since both of the McMichaels were down the street when this encounter occurred between Arbery and Roddy Bryan, but the dispute will be over how did it happen. If it's his handprint and his shirt fibers that are on Roddy Bryan's car, the state contends it's because Roddy Bryan hit him with his car. We don't see any support in the evidence for that. It looks like Arbery himself hit Bryan's truck. Why he did that, you heard today perhaps Kevin Goff arguing that he did that in an effort to get into Roddy Bryan's car, and that's going to be a matter of interpretation. That's what Roddy Bryan says he thought was happening. He says he wasn't trying to hit Arbery with his truck, that Arbery was trying to get in his truck for some reason that Roddy Bryan concluded was not good for him. So it'll be a contested issue at the trial. It'll primarily occur, though, between Roddy Bryan and the state.
Can you tell us, Franklin, what do you want us to know about the story that you anticipate presenting to a jury on behalf of Greg McMichael?
Well, most of what I will want the jury to know, I'll have to hold until the jury is seated. But I think it's probably obvious from the motions hearings we've had so far that our defense is that Greg McMichael left his home that day in an attempt to effectuate a citizen's arrest of a person that he believed was a suspect in at least a burglary or more, perhaps other crimes in their neighborhood where lots of crimes had been occurring over as long as a year. But really in the last few months, they'd seen videos of Arbery himself, this is undisputed, in the English house. And they figured, well, English had had items stolen. Here's a guy repeatedly in the house at night. On that Sunday afternoon, Greg sees the guy running past him at a high rate of speed. He immediately concluded he's running from some trouble he's in, that somebody spotted him, which indeed had happened. A neighbor down the street had seen him in the house and had called 911. That'll be part of the case as well. So he went out that day with his son Travis to detain Ahmaud Arbery long enough for the police to arrive to take over the investigation and do what they do. They would have then inquired of him if he had spoken to them. What are you doing here? What's going on? Let's get to the bottom of this. And who knows what would have happened. Obviously, that's not how things turned out. But that's why they went out there that day. And as everyone has seen on the video, it turned into a tragedy, but not one that the McMichaels intended to occur, wanted to occur, and now are in a position to defend against.
And Bob, is there anything that you would add to that on behalf of your client, Travis McMichael?
Yes, and without trying the case here today, I think it's important to know that there is more to the story than just the 36-second video, that the McMichaels were both aware from Larry English, from neighbors, and from their own experience with Ahmaud Arbery on February 11th, that he was in a house he was not supposed to be in, that things were missing from that house, and that he was potentially armed. And they had a good faith reason to believe he was armed on February 23rd based on Travis's experience with Mr. Arbery 12 days earlier. And so out of a sense of duty, a sense of obligation, not to themselves, but to the neighbors in the neighborhood, when he runs quickly down the street with another neighbor motioning that he's the guy, and they recognize him as that guy, they did what a good citizen is supposed to do. They tried to effectuate a detention until the police could come and do their investigation and possible detention.
And Bob, I know that you're referencing the citizen arrest law in place in Georgia when all of this occurred. Tell us about, and let me start with you if I could, Bob, about, I believe there was a state's motion wanting some instruction to the jury about citizen's arrest. Where does that stand currently?
If I'm remembering correctly what you're asking, the state filed a motion to prohibit us from talking about the new citizen's arrest statute in Georgia because they were afraid that by implication it would appear to the jury that because the McMichaels acted within the current citizen's arrest statute that the state had to change the law. We have no intention of getting into the new law. There was a law in place. There was a law in place in Georgia for over 100 years, over 150 years, I believe, regarding the rights of a private person to effectuate an arrest. It's a very similar law to that exists in 48 other states in the United States. It's not peculiar to Georgia. And so we do intend to get into that law of what a private person can do when he sees a crime being committed or knows of a crime being committed. That'll be full-throated argument in the trial itself.
All right. Gentlemen, I so appreciate your time today. After a long day of pretrial motions, I just want to give you a last opportunity. Franklin, is there anything else that you would like to add or like us to know?
I don't believe so. I'm just, to piggyback on what Bob just said about citizen's arrest law, it is an old law. It's much older than the Civil War era statute that it's been characterized as, actually mischaracterized as. But it's an important law because it's the door that opens the case to ultimately the self-defense case that we'll raise when the shooting occurs. So everything that leads up to that is all under the citizen's arrest statute, the old one. So it is critical to the case, and we intend to argue that clearly and forcefully.
All right. Bob, anything else that you would like to say or would like us to know?
There's a whole lot I'd like you to know, but we don't have the time to get into it now. I just want the public to know that this case is about the truth and that we intend through every way we know how to put that truth before the jury that's seated in this county.
All right. Bob Rubin, Travis McMichael's attorney, and Franklin Hogue, Gregory McMichael's attorney. Thank you both again for your time today following the hearings. We appreciate it here on Court TV.